lessons learned from a failed private equity specialty pharmacy partnership. Today's short webinar is about a case that the Department of Justice recently settled involving a specialty pharmacy and its private equity owner. We'll take an in-depth look at this case to develop key takeaways for the audience. Before we get going, let's have some quick introductions. My name is Wakaba Tessier, and I am a partner at Husch Blackwell. I specialize in healthcare law, specifically related to specialty pharmacies.
And my name is Erica Ash. I'm also an associate at Husch Blackwell, and I specialize in healthcare law as well. Just a quick note before we get started. This webinar is meant to be a brief overview of some of the issues affecting private equity funds and specialty pharmacies. Because every deal presents its own unique issues, for specific advice about your obligations regarding healthcare compliance or what to look for when buying or selling a specialty pharmacy, you should consult with a licensed attorney who specializes in healthcare regulatory issues. Hey Wakaba, so before we get started, I was hoping you could tell the viewers a little bit more about why you thought this case was important and what it represents going forward for settlements.
Sure. So this past year, Husch Blackwell has presented a series of webinars, and that was focused on compliance, particularly related to buying and selling pharmacies. And so we thought this case was a good example of why compliance is really important. And then we thought what was really interesting was the private equity portion that came into it and how the government wanted to, well, they did allege a false claims violation on the part of the equity firm, which you don't see very much. So, but can you tell us a little bit about the case?
Yeah, definitely. So it was settled on September 18th of this year. It's called United States of America versus Diabetic Care Rx, and that's the specialty pharmacy that was involved. And as you mentioned just now, the reason why it was so significant is that not only did the Department of Justice name 2 executives and the compounding pharmacy, which is going to be pretty typical, but it also alleged that the private equity firm owner, Roarden, Lewis and Hayden, or RLH, was jointly and severally liable for the settlement. And that was a big deal because essentially what you're doing now is owners of specialty pharmacies could be liable for the actions of the operators, which is kind of a new concept.
So was there a reason why the government alleged that the owners, RLH, were liable for false claims?
Yeah, so as we're going to get into a little bit later, the owners, RLH, had a couple of seats on the board, and they tried to retain some control of the pharmacy and helped the pharmacy get into this space, which was compounded topical drugs. And so for those reasons, the Department of Justice, in their initial complaint and then in their amended complaint, said that RLH should also be liable.
And was there individual liability here for like the executives on the pharmacy?
Yep. So the CEO was liable personally for $300,000 and the vice president was liable for $12,000, $788, and those amounts had to be paid personally by each of those individuals, and it was they calculated it based on the ability to pay.
So Erica, we are writing an article about this webinar, more in depth, and I know you worked on the background section, so can you give us a little bit more facts so the audience has more context?
Sure. So in 2012, RLH acquired the pharmacy, and like most private equity purchases, they plan to sell it in 5 years for profit. So at that time, the main revenue source was an IV vitamin solution that was used to give nutrients to end-stage renal patients. So right after RLH purchases this pharmacy, Medicare drops the reimbursement rate for the IV solution. Well, as you can imagine, then the profits also kind of tanked, and in order to get the revenue back up, they needed to figure out a different drug or something else that could be their main revenue source.
And that's because they were planning to sell the pharmacy within 5 years, right? They had this business plan that they were going to acquire this pharmacy, rack up a lot of revenue, and then sell it within that 5-year time frame.
Exactly. So that brings us to 2014, which was the Pain Management Initiative. So like most private equity deals, there were 2 RLH partners on the board of the specialty pharmacy. So these two partners started a pain management initiative, and they determined that compounded topical pain medication, the reimbursement was extremely high for those drugs. So they decided to switch gears from this IV vitamin solution and into this topical pain medication. And at that time, they also changed their name from Diabetic Care Rx to Patient Care America, or PCA.
What was the reimbursement rate for the compounded topical pain medicine? Do you know, like, the range?
So at that time, they determined it was anywhere from $1,000 to $8,000 per medication. But then, depending on which payer you go to, obviously these rates could be higher or lower. And as we'll see later, they were extremely high for certain payers. So now that we have a little bit of background, Wakaba, can you explain the DOJ allegations to us a little more?
Sure. So the DOJ alleged that PCA participated in two schemes that violated the kickback statute, and that's the kickbacks to the marketers and then kickbacks to the patients. Also, because the government alleged that PCA violated the kickback statute, the government also claims that any claims that PCA submitted to the government were false claims. And so that's where the violation of the False Claims Act comes. So I've been talking a lot about what PCA did, but I know you're wondering what RLH did, right? Because that was kind of how we started off the webinar. And that is definitely coming. But I think we need to understand a little bit more about what those two kickback schemes were. So we'll do that in the next couple slides.
Okay, so first we're going to talk about the kickbacks to the marketers. This diagram looks confusing, but bear with us. PCA, pictured in the middle, would enter into contracts with different independent marketing companies to provide its sales force rather than hiring an internal sales force. And those marketers are pictured into the left, and they have the bullhorn. PCA agreed under marketing contracts to pay the marketers 50% of the profit from any of the prescriptions that the marketers sent to PCA and were reimbursed by a payer. Early on in this arrangement, the marketers discovered that TRICARE, which is a government payer for military personnel and their family, had the highest reimbursement rates for the compounded topical drugs. And for that reason, the marketers began targeting military families specifically to sell the drugs to. And the patients are pictured in the top left corner. Now, in most cases, the marketer would send the patient's information as a referral to a telemedicine physician, and the marketer would also pay the physician a consultation fee, and that's pictured on the left. So as the purple arrows are showing you, the marketers, not the patients, paid the physicians, which is a big issue. Then, most times, the marketers, not the patients or physicians, would also fax the prescriptions to PCA pharmacy, which is the bottom orange arrow. So then PCA would fill the prescription, send it to the patient, and bill TRICARE for the prescription. This reimbursement that TRICARE would pay was anywhere from $5,000 to $16,000 per prescription for a topical scar gel, and $1,000 to $8,000 per prescription for a topical pain cream. What you may have noticed is that I did not mention anything about copays in the last slide, and this brings me to the kickbacks to patients. One of the marketers became frustrated because his company would lose a potential $16,000 payout for a patient's refusal to pay a $40 to $100 copay. To get around this issue, his company, Telemedtech, set up a fake nonprofit. PCA Pharmacy and Telemedtech would fund this fake nonprofit and pay all of the patient copays, regardless of the need and without even looking at whether or not the patient had the ability to pay. In all, the nonprofit entity paid for 3,477 copays, resulting in $16 million in reimbursement from TRICARE. The marketers would also recruit military families to become sales associates for them. When their friends and family saw how much they could make per prescription, some of the former patients became salespeople and would send prescriptions in for themselves and their family members who were also TRICARE beneficiaries.
Thank you, Erica. So let's do a quick refresher of the anti-kickback statute, since that was what the government alleged that PCA did wrong, as well as RLH. So the anti-kickback statute, as you can see on the slides, prohibits knowingly and willfully offering or paying any remuneration, including any kickback, bribe, or rebate, directly or indirectly, overtly or covertly, in cash or in kind, to any person to induce that person to refer an individual for the furnishing or arranging of any item or service for which payment may be made in whole or in part under a federal health care program. So, as I mentioned earlier, the DOJ alleged that PCA's actions were in violation of the anti-kickback statute. And because they violated that anti-kickback statute, the government also concluded that any claims for payment arising from these violations and submitted for payment to the government were false claims, and therefore a violation of the False Claims Act.
So, Wakaba, how does the government usually prove that someone knowingly broke the law? How can they prove what you knew or didn't know?
Sure. So first of all, it's important to know, and I think the audience probably knows, that the anti-kickback statute is an intent-based statute. So what that means is if you are paying someone for referrals, and you're obviously knowingly doing that, right, because you're paying for referrals, then that violates the anti-kickback statute. Even if there is 1,000 reasons for paying someone, if one reason is to induce referrals, then that is a knowing or willful violation of the kickback statute. And also here, and correct me if the facts are wrong, but I think here PCA actually got some legal advice related to these alleged kickback schemes from their lawyers, and the lawyers had advised them that these schemes were probably in violation of the kickback statute. They probably provided some advice with respect to how they can enter into these arrangements separately, and they had written memos about that, and PCA apparently ignored them. So when that evidence comes into play, that is certainly, I think the government will certainly classify that as a knowing violation. So, Erica, question. Does violating the anti-kickback statute and submitting claims as a result of those violations always result in a False Claims Act violation?
So, not necessarily. So, here we have the elements of the False Claims Act, or FCA. So, violating the anti-kickback statute, so that would satisfy one, making it a false or fraudulent claim. And also, as we talked about in the prior slide, you will also be doing it with knowledge that the claim is false because you knowingly entered into this kickback scheme, not you personally. But the thing that isn't always satisfied is number 2, which is known as the Presentment Clause. So the false claim must be presented or caused to be presented by the defendant to the United States for payment or approval. And that we're going to dive into a little bit more on the next slide.
So in this case, Erica, this presentment clause, the second one, which was in bold red, that was the issue with the government's pleading in this case, right?
Exactly. So that's the reason the court dismissed the government's first complaint and the reason why it filed its second amended complaint, which the court never actually ruled on because the case settled before that.
So what was the deal with that presentment clause? Because as we recall, the presentment clause says something to the effect of you must, as part of the False Claims Act, you must have presented or caused to be presented by the defendant to the United States for payment or approval. And so what was it about that presentment clause that the court had to rule on?
Exactly. So this level of involvement required to meet this is extremely hard for the government to prove in relationship to owners because it requires the owner to have a lot of involvement of the day-to-day happenings. So submitting claims for payment, usually an owner or a shareholder isn't going to have that much involvement at the granular level.
As opposed to the provider who is actively submitting claims.
Exactly. And various courts have held that even if a defendant has knowledge of its wholly owned subsidiary's fraud, does nothing to stop it, and is even benefited by the fraud, it's not necessarily enough to show that the defendant caused a false claim to be presented.
Got it. And do we know how much involvement RLH had? Like, were they actually submitting claims? I don't think that was very clear in the documents that we read.
The complaint made it seem as though the level of involvement was 2 board members and then also recommending a new CEO and then recommending that the specialty pharmacy enter into this space, and then also loaning it money from time to time. So it wasn't necessarily involved in the day-to-day business of submitting claims to the government.
Got it. And so in this case, I think that the court, you said, never ruled on the motion to dismiss, or the second motion to dismiss, right, that RLH filed. But I think this also poses huge risks, right, for future and our listeners, because these risks could include huge litigation costs, adverse publicity, state AGs pursuing a separate action, and costly CIAs. So settlement was likely the best option here, but it's a really good lesson learned for equity firms to not get too involved in what the providers are doing.
So Wakaba, you sort of just alluded to this, but as an attorney, what do you think private equity firms should take away from this case?
Sure. So I think the first one is leave the day-to-day operations to the pharmacy. So in this case, the government tried to allege that the PE firm was liable itself because it had sufficient control of the pharmacy. And Erica, you mentioned a little bit of that, but those were suggesting entry into a new product line, which was those really expensive topical compounded skin product, loaning money to pay the marketers before the government reimbursed the pharmacy, and then suggesting to PCA who the new CEO should be so that their agenda was supported. And these actions were exactly what caused the DOJ to target the private equity fund as well as the pharmacy itself. This isn't to say, though, that the private equity firm can't have board members on the provider side, but there are certain functions that boards do and certain things that boards don't do. And I think it's important to understand the regular board activities, keeping those in mind and not getting too involved in the day-to-day operations. And I think the second one is it's very important to do due diligence. We touched upon this in a prior webinar series about due diligence related to the buying and selling of a specialty pharmacy, but really doing the due diligence of that provider will help ensure that the portfolio company or the PE firm the portfolio company will be profitable in the long term. It'll also help ensure that any profit made from a later sale will not be tied up by any indemnification obligations in the event that there is any foreseeable fraud, waste, or abuse issues that arise during due diligence.
So, as you mentioned, the private equity firm should leave the day-to-day operations to the specialty pharmacies. So, what, if anything, should the specialty pharmacies take away from this case in regard to their day-to-day operations?
I think at the end of the day, the responsibility to comply with the applicable laws and regulations is the pharmacy's job. It's the healthcare provider's job, and it can't be delegated. So, in this case, the DOJ emphasized that the pharmacy should have known, and in many cases it did, which we'll talk about next about what it did and did not know based on their attorney's advice. They did know what the marketers were doing. For example, the pharmacists did not verify the medications, or that they didn't verify that the medications were medically necessary, even though they had every reason to question those prescriptions. The second one, I gave a little preview, is about knowing or heeding the advice of counsel. And so, Erica, we touched on this multiple times, but do you want to tell us a little bit about the advice that PCA received and the advice that they ignored?
Yeah, so when PCA was thinking about entering into the 1099 contracts with marketers, it sought an attorney to see how it should handle its relationships with these marketers. And the attorney advised PCA that first, the pharmacy should not pay the prescribing physicians, and neither should the marketers. The marketers should not pay for third-party referral sources, and also that the pharmacy should not bill government healthcare providers for these scripts, because billing government healthcare providers is what's going to impact the federal anti-kickback statute and the fraud, waste, and abuse laws. So here, PCA failed to follow any of this advice, which we talked about earlier. And at trial, the government could use the advice of counsel to prove that PCA knowingly submitted the claims in violation of the FCA. Now, I know we've talked about this a lot, but what other enforcement actions could violating federal laws lead to?
Right. And I think this is the potential domino effect of enforcement actions, right? We've focused so much on the Kickback Statute and the False Claims Act, but it can also lead to much more liability. So, for example, most states have their own fraud, waste, and abuse laws, so a violation of the Kickback Statute or other federal statute could lead to state enforcement action as well. Depending on the violation, there could be a state licensing inquiry, not only of the pharmacy itself, but also of the pharmacists within your state. For example, maybe it was the pharmacist's responsibility to ask about medical necessity, right, when they got the scripts and they never did. So there will likely be questions raised with respect to licensure.
So what if your license gets terminated in one state, but you're licensed in all 50 states?
Right, and this is actually a real issue for a lot of specialty pharmacies that dispense their drugs through mail. They tend to be licensed in many states, and so if you're disciplined in one state, or there's any sort of curtailment in your abilities to dispense in one particular state, then all of a sudden you have a notice obligation to all the other states in which you hold licenses. So that's something to keep in mind as well. And most significant penalty, though, is probably that, well, besides going to jail, I guess, and paying a lot of money, but one of the other most significant penalties is exclusion from participating in government healthcare programs for violation of federal statute. This is usually going to be very important for any pharmacy thinking about buying or selling, any pharmacy that wants to continue providing healthcare services in this industry. So that's something that is very important, and this is one of the critical domino effects that could happen. So, well, thank you, Erica, for joining me on this webinar today. We hope that the audience enjoyed listening to our mini webinar. If you have any questions, please feel free to email either Erica or me. And we have an article that we're working on, I think we alluded to at the beginning of the presentation, that we're working on, so look out for that as well. Thank you very much again for listening to our short webinar today.